Hello everyone, today we will talk about contributory negligence. First, let me explain what contributory negligence is. Contributory negligence is a legal defense that applies when the claimant's own negligence or fault contribute to the damage or injury they have suffered. Instead of preventing the claimant from making a claim altogether, the court will reduce the amount of damages awarded based on the claimant's shares of responsibility for the loss. According to Section 12(6) of the Civil Law Act, the term fault include negligence, breach of statutory duty, any act or omission that give rise to liability in tort or would otherwise amount to contributory negligence. Next, we will talk about the elements and the real-world example for contributory negligence.
Hello everyone, now that we understand what contributory negligence is, how does a court actually prove it? It boils down to three essential elements. First, the plaintiff's faults. The defendant must show that the injured party failed to take reasonable care for their own safety. Second, causal connection. This self-care failure must be a cause of the damage. If their carelessness didn't actually contribute to the injury, this defense fails. Third, foreseeability. The plaintiff must have been able to reasonably foresee that if they didn't act carefully, they could get hurt. Let's look at a classic example. Imagine you are willing to get into a car knowing the driver is heavily intoxicated. If a crash occurs, the drunk driver bears the primary responsibility, let's say 90% at fault for reckless driving. However, because you knowingly took the risk and failed to protect your own safety, the court holds your 10% contributory negligence. As a result, your compensation is reduced by 10%, leaving you with 90% of the total damages.
Hi, I am Chen Hao and will be sharing the facts for the case law. The case law that we are referencing is Ahmad Zubaidi Anwar versus Muhammad Shahril Abdul Rahman, which arose from a road traffic accident. On the 15th December 2017 at 2 a.m., the appellant Ahmad Zubaidi Anwar was riding his motorcycle along Jalan Changkajo, Teluk Intan, Perak, when he collided with a car driven by the respondent, Muhammad Shahril. The appellant suffered serious injuries and commenced legal proceedings against the respondent, claiming the accident was caused by the respondent's negligent driving. Parties gave different accounts of how the accident occurred. The appellant alleged that the respondent had made a dangerous U-turn into his lane, leaving him with insufficient time to avoid the collision. In contrast, the respondent claimed that the appellant was speeding at that moment, causing the accident. It was also established during the trial that the appellant did not possess a valid driving license with tax or insurance at the time of the accident.
Now, I will explain the outcome of the case Ahmad Zulfedi Anwar versus Muhammad Shahril Abdul Rahman and how it applies to the principle of contributory negligence. The Court of Appeal decided that the defendant was 70% responsible for the accident, while the plaintiff was 30% contributory negligent. Before this, the High Court had increased the plaintiff's liability because he was riding a motorcycle without a valid driving license, road tax, and insurance. However, the Court of Appeal disagreed with this decision and restored the original apportionment of liability. The judges explained that although riding without a license, road tax, or insurance is against the law, these offences did not actually cause that accident. In contributory negligence, the court looks at whether the plaintiff's own careless action directly contributed to the accident or the injuries suffered. This case teaches us an important legal principle. Breaking the law alone does not automatically make a person contributory negligent. There must be a clear causal connection between the person's conduct and the accident. In this case, the lack of a license and insurance had no direct link to the collision, so they could not be used to increase the plaintiff's liability.
Hi everyone. In conclusion, this case confirms that negligence must be tied to the actual cause of the accident. The appellant had breached road transport by law riding without a license, road tax and insurance. But the court held that those breaches did not by themselves make him more responsible for the collision. Since there was no causal link between those breaches and the accident, the additional 30% liability imposed by the High Court was set aside. The original 70-30 liability split was restored, and while the income claim failed for lack of evidence, the appellant was awarded Rm 50,000 for loss of earning capacity. Thank you.